Melody, I hope.
Yes, Mr. Howe.
I hope over the short adjournment, all members of the court received an
We did, thank you.
Perhaps one document that you weren't expecting in that email was the framework agreement for court-appointed intermediary services.
I assume that was highly confidential.
Well, my understanding is it came to the FLBA by a Freedom of Information Access request, and it's instructive in our submission. It's really, if the court's able to go to page 53 of that PDF, there's a helpful table.
I'm left my computer on my desk, so I'm going to share.
Okay,
there's a helpful table that sets out what this contract requires of the intermediary service in relation to criminal cases, then family, civil and tribunal cases. And we see from this that assessments and hearings...
What page are you on? What page of the document?
Bottom of the page 53, there's a table with blue colouring.
I can see it's fine.
So family and civil is the very bottom of the page.
Yes.
So the contract covers funding by HMCTS if ordered by the judge for assessments and hearings, but also the bottom box, conferences of support outside of assessments and hearings. So as I was making submissions this morning on the court having jurisdiction under the rules to order it, it's an order that's also anticipated in the contract that the MOJ entered into with the providers. Just following up on a question from this morning as to why the local authority paid or was directed to pay for the intermediary assessment of the other person in the pool. That was, I'm told, because the fact-finding hearing was originally listed on 20th of February. It was thought there was no time for a prior authority to be obtained. So despite a representation to the contrary, the learned judge directed the local authority to pay to try to preserve the listing of the fact-finding hearing.
Thank you, that's helpful. Now, was there anything else you wanted to?
No, simply to move on to the authorities as my Lord requested me to do so. It perhaps comes as no surprise to this court that the local authority submits that my Lord Justice Peter Jackson got everything right in RES 2020, which is in the authorities bundle at page 89. Where at paragraphs 16 to 21, this court sets out a paragraph 16 the three questions that the court must ask itself. Recites the provisions of the rules. There's a typo at the end of paragraph 18. It's rule 3A8 D&E.
At the end of paragraph
18. Last line.
Oh, I see. It's not 1. It's 8. Is it?
It's 8, my lord. Yes. And then it really sets out the factors at 3A7 that the court must have regard to when deciding whether to make a participation direction. And at paragraph 21, importantly, as has been submitted this morning, the decisions made within the context of the vulnerability in the proceedings and the role that the party has within them, as set out in the practice direction. And so the local authority submits that there's clear authority from this court as to the exercise a judge must undertake when hearing these applications, often at very short notice. If we turn to the decision in the West Northamptonshire case, which is at page 6 of the authorities bundle. And the section where Mrs. Justice Leaven addresses the law. She states, she quotes from rule of 3A1 and says there's no further guidance on their appointment or role. With respect to her ladyship, there was the decision in Ries, and indeed my lady's decision in Rien, that provided a very clear position on what the law is, what the rules require.
Should we be looking at Rien first?
Yes, well, Rien
I
was
see it was referenced in Ries, but we've got Rien.
Yes, Rien is page 79 of my Lord's authorities bundle, and looking at paragraphs 44 to 51. My lady provides a history of how the rules came into being. Then at paragraph 44, addresses 3A.4 and 3A.5, so the two elements of the proceedings that the court needs to consider when making participation directions. Emphasises the duty of the court and all the parties at the top of page 80. And then in paragraph 45, again, it is clear the court must consider whether to make participant directions, and where the court has decided that a vulnerable party or witness is to give evidence, it must hold a ground rules hearing, and then moves on to consider fair trial authorities. The paragraph 51, this court says clearly, in my judgment, Part 3 and its accompanying practice direction provide a specific structure designed to give effective access to the court and to ensure a fair trial for those people who fall into the category of vulnerable witnesses. A wholesale failure to apply Part 3 procedure to a vulnerable witness must, in my mind, make it highlight the resulting trial will be judged to be unfair. So that's the decision that came first. Then my Lord's decision in Ries in 2020, and then back to the West Northamptonshire Council case, page 6 of the authorities bundle. My Lord invited submissions as to where we submit this decision falls into error. And well, firstly, we say it fell into error.
Just for complete clarity, if there are parts that you also consider are not in error but are valuable, then those also, please.
Yes. I've got different colours in my highlighter too, right, for different parts of the judgment, my Lord. So in relation to the judgment, paragraph 43, Her Ladyship refers extensively to R versus Thomas, and she says, although there are obvious and important differences between family court cases and those involving criminal charges, the reasons for the appointment of intermediaries and their function in assisting with communication are essentially the same. Having identified the differences between the two sets of the proceedings, and the interveners have talked at length of this in their documents, and I'm not going to repeat what they say, but really to take perhaps a slightly different point, because Her Ladyship relied on a decision in a criminal case about the rarity of intermediaries being required for specific tasks. Now, of course, family proceedings, particularly public law family proceedings, are very different. The court that is engaged with parents who often have specific difficulties, which is why they've come to the attention of the local authority, why the children need safeguarding. Often, parents in public law proceedings have cognitive and communication difficulties, and there are a number of research papers by the Family Justice Nuffield Family Justice Observatory that address this. Again, it's something that came to me overnight and this morning, so I haven't provided the court with their references. But June 2024, research had found that 34% of parents facing removal of an infant from their care had learning disabilities or difficulties. And there was a similar piece of research the year before by the same organisation, published on 23rd of January, simply saying that parents with communication needs or neurodiversity are disproportionately represented in proceedings before the family court, particularly in public law. So comparing what might be rare in criminal proceedings with what, in fact, is much more commonplace in public proceedings, it is, in our submission, a false comparison. So whilst there is much that is said in the judgment...
Well, this judgment, which starting at paragraph 41, goes on for several pages, but we actually see the decision that the judge was tasked with taking between paragraphs 37 and 40, don't we?
Yes.
I mean, it was effectively an uncontested application for an intermediary for somebody who was profoundly deaf. The judge doesn't appear to have had any submissions about the general position.
Yes, and we'll see the same when we come on to the X and Y. That was an agreed application, which was again didn't fall easily on the judge deciding it. In this case,
I mean, obviously, with full respect for the judge, but I mean that if we're being technical about it, this is not only obiter, but unopposed and without submissions.
Yes, and the application was indeed granted. So the outcome.
That's why it's obiter, but yes. It would have been granted whatever test you're applying.
If I may, my lord, looking at the principles to be extracted, this is often, as the court will understand, when following authority such as this, the lawyers go to the principles and make submissions on the principles, and the judges are welcome for the shorthand in a busy list. The suggestion that it will be exceptionally rare for an order of intermediary to be appointed for the whole trial, well, that might be right statistically in criminal proceedings from the authority that it was drawn, but in our submission, it's not so rare in family proceedings, and that's not saying that's a bad thing. An assessment has been made that it's necessary to facilitate fair participation for an all-trial order to be made. The all-trial order should be made if it's made following the legal principles that have been set out in the early decisions of this court. The suggestion that intermediaries are not to be appointed on a just-in-case basis, well, perhaps those working in the family justice system on this side of the bench might say we don't ever apply on a just-in-case basis. There's a reason why the application is made. 45B, I completely agree that the judge must give careful consideration not to merely the circumstances involved, but also the facts and the issues in the case. That's
And part of the list of 7.
part of the list. 45C, intermediaries should only be appointed if there is compelling reasons to do so. That's not the test in the rules. Rules require the test of necessity, and a decision of the High Court shouldn't change that. We completely agree with D in determining whether to appoint an intermediary. The judge must have regard to whether there are other adaptations that will sufficiently meet the need to ensure the defendant can effectively participate in trial. That's again looking at it holistically, comparing all the possibilities. What can the court offer? What can the lawyers offer? And only when that it doesn't meet the needs of the case at that particular hearing is an intermediary necessary. And again, E, the application must be considered carefully and with sensitivity, but the recommendation by an expert for an intermediary is not determinative. Decision is always one for the judge. Absolutely, there's no disagreement with that. F perhaps is more controversial, and again, it must be case specific in our submission. If an intermediary,
this finds its way into the guidance, doesn't it?
yes, an intermediary can't be found. Should a case go ahead or a case be adjourned?
It must depend, mustn't it?
Absolutely, absolutely. It depends on if necessity has been established. One has to question how the hearing could go ahead without that necessary measure being in place. Clearly, the court has the power in the family court to review its own decision at every hearing, and if an intermediary can't be, there are other measures that, on reflection, might meet the needs of the case and that hearing, then that can be reconsidered. But there shouldn't be any presumption against an adjournment if measures are not adequate and the intermediary remains necessary. G, again, we agree this is appropriate. Steps that can be taken to assist the individual to ensure effective participation if there is no intermediary appointment. It just lists those matters that advocates know.
So it's A, C, and F are really the ones that.
Yes, A, C, and F are the ones that we disagree with, my lord. And paragraph 47, where it's the "and finally" comment. It's the role of the judge to consider whether appointment to an intermediary is justified. It may often be the case that all parties support the appointment because it will make the hearing easier, but that's not the test the judge needs to apply. Again, experience tells us that people make these applications because they have their own engagement with their client, and they consider the communication needs of the client require that the court considers this, and it is always the decision of the judge. And so we, whilst we agreeing it's the decision of the judge, perhaps take issue with the suggestion that these applications are made when they really shouldn't be, just to give lawyers in the family court a slightly easier time. Turning, if I may, if we just scroll through to page 10 of the authorities bundle, which is the decision of Mr. Justice Williams in X and Y. Paragraph 5 at the bottom of page 11. His Lordship says, in delivering this judgment, it seems to me to illustrate some of the issues which are emerging in the family courts in relation to the use of intermediaries. They can be an essential component in what the court provides to a party or witness to enable them to participate fully in the proceedings. He then goes on to the issue is, however, where it is appropriate to direct use of intermediaries, they are not to be used as some sort of safety net or security blanket for lawyers or courts, but only where there is a necessity. It's the same point I just made about the judgment of Mrs. Justice Leven. These aren't applications that are made without reason. The legal framework is then set out in the sections of this judgment that follow, and his lordship then addresses what he describes as the limited or the narrow remit for an intermediary at paragraph between E and F. He says, whilst I do not think, albeit without hearing full argument, the definition should necessarily be interpreted as meaning an intermediary can only perform those functions, it does give an indication of what their primary function is, thus assisting a party during a hearing to understand the evidence given by others, or assisting a party to read papers and give instructions as function not identified in the rules and one which requires to be evidenced. For the reasons given in submissions this morning, it's our submission that's not correct. The rules do explicitly provide for that function to be performed by intermediaries. We endorse what's said in paragraph 9, that the test is necessary. But then at the end of that same paragraph, his lordship then moves on to a test for a very different order, when he says whether that means that nothing else will do would require consideration of all the other means by which fair participation can be achieved. The test of necessity is given in Re H&L, somewhere between indispensable on one hand and useful, reasonable, and desirable on the other. It could be interpreted that adding nothing else will do is raising the bar even higher, and in our submission, that is not what is required by the rules. Paragraph 11, if I may jump onto that. Again, we entirely agree with his lordship's comments that an intermediary should not be the default position for a witness or a party, and only if their fair participation cannot be achieved by other means will intermediary be necessary. And he goes on to say, only if the court is satisfied that the usual support of a legal team, adopting the use of tools available and measures available to the court, would not enable the party to participate fully, will it be necessary to provide for an intermediary? And we agreed that this morning. The court's undertaking a holistic exercise, seeing what is available and deciding what is necessary to meet the needs of the client and the case. It's at paragraph 17 where his lordship refers to the decision of Mrs. Justice Leven and the comments about exceptionally rare and compelling at 17.1 and 3, that we disagree that that's the appropriate test when determining these applications. And at 19, it's the passage that was referred to this morning, where his lordship talks of the spectrum. He says that at the middle of, just above letter H, at the bottom of page 18, the spectrum of vulnerability will self-evidently be very wide. Only towards the far end of the spectrum will be the cases where an intermediary is necessary for giving evidence. Only at the far end will be cases where an intermediary is required for the whole of the hearing. And only at the very rarest cases is an intermediary likely to be necessary to enable the party to give instructions in advance of the hearing. We set out in our skeleton that the experience of the local authority and indeed of this social worker is that clients come to meetings and they're not understanding. So the local authority commission and fund lay professional advocacy services to attend to assist in understanding, and in certain circumstances when necessary, a local authority will commission an intermediary to attend meetings. So we're not. Clearly, there is a spectrum, but the need for a vulnerable witness with comprehension and cognitive difficulties to be assisted at meetings, in our submission, is as relevant in important meetings as it is in a court hearing. Professionals are discussing their family and their future of their family life, and it's important that they are able to understand it. And we've seen this morning the rules that enable that service to be provided. The controversial part of paragraph 20 is really the first line in relation to the application. As the rules make clear, decisions on the use of intermediary require evidence to establish that their use is necessary. Well, actually, the application requires information. The more information the court has, the better for the making of the decision.
But is the rule actually saying any more than this is what your application has to contain? It's not setting out whether you should be supporting your application by evidence.
It's once the application is issued, then the court could make case management directions on it.
But then you're adding another layer.
Exactly. The reality of these applications, the lawyer meets their client for the first time, is concerned about their comprehension and their communication, and makes an application either for a cognitive assessment or an intermediary assessment. And it's the experience of the lawyer meeting their clients that leads to the application. And so in our submission, the rules don't require there to be evidence. The evidence for the continuation of that participation direction may come from the evidence that's obtained as a result of the application, if I'm making sense. So the application can be made without evidence. The court may require evidence to determine it, particularly if it's ordered a preliminary intermediary assessment, as was the case in the matter under appeal, and then the court can at some point decide whether that should be granted or not. So I think my submission is that there's a difference between what's required to make the application, and the court can then decide what evidence it requires to determine it.
So you're saying that the first sentence of 20 is just plain wrong on the rules?
Well, as the rules make clear, requires evidence. Well, yes, in our submission, the rules don't make that clear. Don't say that. The rules set out what the court should consider and what the party seeking the participation direction needs to file within the application.
You're saying you have the application, that you don't need to file any evidence. Then it goes to a court for a case management hearing.
Yes.
So is Williams J not just saying decisions on the use of the intermediary required evidence to establish that their use is necessary? In other words, because only the court can commission the intermediary's assessment.
Yes.
Isn't that what he's talking about?
Well, it depends what the distinction between evidence and information is. If all the court has is the Part 18 application signed by the solicitor saying this is my experience of my client, we make an application for an intermediary assessments, then that's all the court often has.
Isn't the real point about this where evidence reappears just below letter B? Because it's obvious that whatever one calls it, the court needs something upon which to get its teeth into under sub-rule 7. Where does the court get that from? But from information which is likely to be in the form of evidence that has been gathered one way or another. But it isn't your main point evidence from their legal team?
Yes, but that's the difficulty. In this case, there was evidence from the social work team. So in the form of a statement,
it's not most likely that the social worker may have, and did in this case, have something valuable to contribute. But very often, as you've told us, it may come from the applicant's own team.
Yes.
What is being said here, and is more caution not required the second time round where evidence from the legal team, in the sense that it may not be appropriate that should formally be evidence.
Yes. My Lord has
Rather than in the form of informed submissions made by professionals who are in a position to know.
That's exactly the point, my Lord. Yes, as it's a step too far asking a counsel or solicitors to sign statements to put evidence before the court in relation to their experience of their client's communication needs, when it can simply be done by the signing of an application form and information contained in a position statement. Why does it need to be any more than that? For the court to consider the factors set out in the rules is what we submit, and I note that the same queries are raised by the FLBA and the ALC. In relation to the other decisions, the Oxfordshire decision, which is at page 94 of the authority bundle, it announcement doesn't really add anything extra. The Mr. Justice Williams considered the application there and reached the view that the court and the lawyers could manage the communication needs of the party who was making the application. The paragraph 12, where he concludes, "I'm not satisfied that an intermediary is necessary to assist the mother. Ability to participate may be reduced to a limited extent by diagnosis, less so by her cognitive functioning. Any deficit can be addressed by appropriate work by a legal team in court." And it says the attendance of her solicitor at court or at the next hearing, or the mother's attendance at her solicitor's office if the hearing is remote. It will provide a significant measure of support. Of course, the landscape in the family court.
Sorry, I lost the reference to where you were. Sorry.
I'm at paragraph 12, bottom of page 98, my lord.
Sorry.
The landscape in the county court is an advocate acting alone. The having a solicitor in attendance it is uneconomic. Solicitors don't send anyone to sit behind counsel. I'm told that the rate is £29 an hour if solicitor sits behind counsel on a non-high court a family case. The contract rate for intermediaries was £10 more than that 4 years ago when I could last find information. So that's put some context to what the court can deliver. And as we set out in our submissions, all the functions the intermediary recommended, and how is counsel alone expected to do all of that, and take a note and cross-examine the witnesses and address the court. It's simply not something that's possible. So we very much endorse the decisions of this court, so that each case is looked on a case-specific basis. There's no gloss about rarity or exceptionality. The court looks at the hearing coming up and looks at the participation directions that are required to prepare for it and for participation within it and the giving of evidence. I hope I've said enough.
Practice guidance. Practice guidance.
Yes.
Could we just lastly look about to see what parts of that we need to be focusing on? Page 2 of the...
Yes, that's in the supplemental bundle. It's page 2 of the supplemental bundle. Moving through to paragraph 7. Where the guidance states that whilst they may assist a party or witness to participate more generally, the primary function of an intermediary as defined is limited to the process of communicating, explaining questions to a party or witness within the court process, and the communication of such answers as they may give for reasons already articulated in our submission. That's not the complete picture, and that intermediaries are, when we say with some regularity, required to assist, to explain the evidence, both in the court building and out of it, if there's assessment as to the necessity. The advocates should familiarise themselves with the observations in the 3 cases mentioned. Well, if this court agrees with the submissions made that we make and those made by the FLBA and the ALC, supported by others, it's the judgment this court gives that the advocates should familiarise themselves, together with the earlier cases of this court that provided the more open approach compliant with the rules without the gloss that has now appeared.
I wasn't able, just reading generally the guidance against the cases, to detect any real difference between the guidance and the cases. The guidance faithfully follows the cases, doesn't it?
Yes, it's very much drawn from those
Yeah.
3 judgments, primarily the Northamptonshire case and X and Y. Again, paragraph 9. There's the qualification.
Could we just take it in turn? Do you mind going back to paragraph 4?
Yes.
Clearly the impetus for this was a belief that intermediaries were being more widely used than was appropriate on a correct application of the rules. At the end of paragraph 4, it said that an approach where it in effect takes account of the wide variety of forms of support will likely reduce the number of cases where an intermediary is considered necessary.
Well, it's the guidance.
I'm not sure where that's anchored, as it were.
We are as confused. It's giving an aim to the guidance, where actually the aim should be that the rules are followed and judges are assisted in how to deploy those rules and reach their decisions by authority that doesn't contain the gloss that's not contained in the rules. Whether that actually reduces the number of cases where an intermediary is considered necessary will remain to be seen. 10 years ago, we didn't have these rules. 3A and 3AA weren't part of the rule book, and there's a better understanding of vulnerability and its impact on participants in court proceedings that develops with every piece of research being released, and the professions and the judicial college, judiciary, everyone responds accordingly when and as we should, where there are lessons to be learned, that we can provide a more effective court environment for the parts of the community that we serve.
But if we take this paragraph and apply it to what goes on in a solicitor's office, as opposed to what goes on in the court building, it may very well be right, isn't it, to say that if you, in your day-to-day professional practice, parties, professionals, it says advocates, right? But if advocates and solicitors do consider how to give support and make reasonable adjustments in relation to what goes on outside court, where they're not being distracted by what is happening during the court hearing, because we all know you can't act as an intermediary whilst you're on your feet, as it were.
Yes.
Then, to the extent that would be suggested that an intermediary is necessary for that type of work, it may well be the case that if professionals educate themselves and provide support with reasonable adjustments, then certainly there would be less need for an intermediary for that area of work.
If there was an evidence base that demonstrated what's asserted in that paragraph, then there can be no complaint with it. It suggests, or it's perhaps implicit in what is written, that many working in the family justice system aren't aware of what they should be aware of, and of course some aren't. But whether following the recommendations in the Advocates Toolkit and the guidance from Family Justice Council will reduce the number of cases where an intermediary is considered necessary remains to be seen. But all the court can do, all the professions can do, is apply the rules as guided by the authority from this court, and it's the judges in the family courts around the land that make the decisions as to whether an intermediary is required. In our submission, the guidance having an aim to reduce the number of intermediary instructions, if that's what it is. Obviously, the court has to protect public funds, but not at the expense of vulnerable litigants who need the support to participate before, for example, their children are removed from their care permanently. My lord, I was moving on to paragraph 7, which is just simply again indicating a limit to the role of the intermediary. That in fact,
I think we've done 7 and 8, haven't we?
Yes, I'm just looking at 7. And we've done 8, and on to 9. Question for the court in considering whether to direct an assessment by or an appointment of an intermediary, whether that direction or appointment is necessary to enable the party to participate in proceedings. Absolutely no complaint with that paragraph. But then at paragraph 10, we return to the concepts of rarity, as is clear from the case law. It will be rare, even where an intermediary is necessary for giving evidence then to be required for the entirety of the hearing. And I'm perhaps repeating myself, it's a decision that's been made on a case-by-case basis when it's necessary. Rarity should not be a factor that's present in guidance such as this in our submission. Paragraph 11, the court may require circumstances may require the court to undertake a more investigative process. Coming back to the submissions earlier about evidence, if there's evidence before the court from a reliable expert that a measure is required, then there may need to be less investigation. But the court interrogating the factors in 3A7 and protecting the public person, satisfying itself that a participation direction is necessary, is entirely appropriate, and the local authority endorses that. Moving on to 12, again, no difficulty with there being a spectrum. The difficulty, we say, is seeking to prescribe when something is rare.
Well, this is a
and
direct
unlikely
quote
to be
from
required.
paragraph 19 of the Northamptonshire case, which you've already addressed us on.
Unless I can assist the court any further, I think those, on behalf of the local authority, are our submissions. We support the appeal, and I understand that a draft order has been prepared. We've not yet had the chance to look at, but we will do so as soon as we have an opportunity.
Thank you very much indeed, Ms. Hand.
My lady, my lords, as you would have seen from our skeleton argument on behalf of the child, this appeal is supported.
Yes.
And I can start by saying that the Guardian is very concerned about the decision that was made. And you will see from our skeleton argument that we have set out in there not only her concerns, but in fact there was a previous Guardian who also had concerns. And if that is evidence or information that would have been required before a decision was made, we say that it is certainly unfortunate that there wasn't a time given for, first of all, proper analysis of the documents before the judge. There has been discussion about how this circuit judge was clearly very busy, and I'm not submitting any criticism of this circuit judge. But as was recognised by Mrs. Justice Leven in that list that she set out, which she'd taken from Crown and Thomas at E, these require to be considered carefully and with sensitivity. And as Mr. Justice Jackson observed this morning, albeit intermediaries are not experts, their appointment can be as important, if not more important, than an expert. I think the example was given of looking into tooth decay. So this deserved, in our submission, a proper analysis. And the procedure adopted of simply stopping after the mother's submissions and then going into judgment, I'm told by my instructing solicitor, was surprising. The judgment that was given was a surprising judgment, and that's why the Guardian feels so strongly about this appeal. Can I just say that in terms of the last point that I think the Ladyship made about the spectrum point, I think that actually comes from X and Y and not from the Northamptonshire
Oh,
case.
beg your pardon.
But I just thought I'd say that while it was in my mind.
Yes, paragraph 10 came from Mrs. Justice Leven, paragraph 12 came from Mr. Justice Williams.
Yes,
So
yes, it's a combination there.
just to pause on the issue of submissions from other parties, clearly it's for a judge to decide what submissions they need before deciding something. But clearly in this sort of case, the provision of an intermediary for a party is of prime concern to that party
Yes.
or that witness. But is it the case that other parties may have an interest in that decision?
Absolutely, my lord. Absolutely. This child had an interest in that application. For these proceedings to be fair, for that fact finding, let's just pause and think about what the nature of that fact finding was. It was going to concern very serious allegations. The effect of those allegations could lead to fundamentally draconian orders. They may be necessary, but they would be orders that would completely take away that child from his family, from his mother. So that child deserves to know and has a right to know that the proceedings themselves are going to be fair for the mother, so that the evidence that are used is the best evidence that that mother can, that the safeguards and tools that are put in place to make sure that that evidence is fairly obtained are there, so that the decisions made at the end of the day are fair and just. And that's precisely why that application does involve, certainly we say, the child. And submissions should have been given by other parties, or the time for them to give submissions should have been allowed.
Many parties may choose not to give submissions and take the view it's somebody else's business. But for example, a local authority in a case like this, where it's seeking potentially a placement order at the end of proceedings, I say potentially,
Yes.
It's of concern to local authority that the proceedings are valid
Absolutely.
and not open to challenge on
later on
unnecessary grounds.
Yes. So it wasn't just the mother that was involved in the decision, it was the child. And yes, my lord, the local authority had a vested interest as well. And the consideration of the information or evidence, albeit that clearly there was very limited time, fell far short of that careful and sensitive approach that we say is actually right in that list from Crown and Thomas that Mrs. Justice Leven sets out in the Northamptonshire case. And there should have been proper time to look at the intermediary report. It's quite clear from the judgment that the psychological report wasn't looked at all, because in fact the learned judge says, well, I believe there's one. Am I right on that, Dr. Love? But there's no pausing, let's have a look at it, let's consider it. And my lady, that goes in as well to the issue of the ground rules hearing, because this is all tied up with an analysis of whether what the court can provide can mean that the intermediary application is not necessary. And we say that that is the test. Without going through what the proposals were for ensuring that this mother's participation within the fact-finding and the proceedings generally was going to be fair, it was difficult to evaluate, nigh on impossible, we say, to evaluate whether an intermediary was necessary. My understanding from my instructing solicitor is that that was listed for a ground rules hearing. Clearly, we can see from the judgment that there was no ground rules hearing. My understanding as well, currently, there is in fact no listing as such for a ground rules hearing. So that appears to have simply fallen away. So one half of the analysis that the court has a duty to undertake, whether you can meet the needs of the mother by other alternative measures, has not been undertaken, and it's not within that judgment. So we say that on those really two grounds, so there's a procedural aspect that it wasn't fairly looked at because other parties were not given an opportunity to give submissions. And secondly, within the analysis, it was lacking because there wasn't the analysis of what, from a ground rules perspective, could make the intermediary application unnecessary. And then, my lady, we do come to the judgment and the test. It is right, I agree with the submissions by Mr. Howell, that in fact the judge rightly identifies very early on that the test is necessity and clearly sets out in summary terms what in fact the court has to undertake. But then creeps into that these other words, exceptionally rare, paragraph 10, rare cases in paragraph 10 about an intermediary assisting the party in understanding the evidence, and then X and Y, cases that may be permissible to consider written evidence and give instructions. And then we have the spectrum. That appears to completely conflate the issue or to confuse the test that this learned judge has to apply. And rather than looking at necessity, the balance is shifted to well, this is only on rare cases. I can't see on an immediate analysis that that comes within that category, and therefore I don't, in fact, have to go any further. The analysis of undertaking the analysis of whether it is actually necessary does not appear within the judgment. And that, unfortunately, perhaps appears to flow from the High Court decisions, which this court has been looking at this afternoon and this morning, with that kind of vocabulary, as well as compelling being the other word that comes into consideration, certainly in some of the practice guidance and documents that have been issued in recent times. So the Guardian, in terms of the appeal, supports the appeal that's undertaken by the mother. We now have seen a draft order. In terms of wider issues, my lady, do you wish me to? I effectively support the submissions that Mr. Howe has gone through in terms of the case law. There is one other passage in X and Y, which is at page 19, paragraph 21.
So page 18.
Sorry, it's page 19.
19, sorry.
Yes.
At the bottom of that paragraph, 4 lines up, it says, in rare cases, an intermediary may be necessary to assist the party to understand the evidence of others. In very rare cases, an intermediary may be necessary to enable the party to consider the written evidence and to give instructions. My lady, it's that use of rare and very rare. It is a gloss, clearly a gloss on the test of necessity. In terms of the practice guidance from the President, you've been addressed already in respect of that by Mr. Howe. We have provided other guidance which has been issued recently. And I wonder would it be useful for the court for me to address you on that?
Is that Mr. Justice MacDonald's guidance?
Mr. Justice MacDonald's, my lady, which is at page 6 in the supplementary bundle.
We've got compelling and exceptionally rare.
You're ahead of me, my lady, yes. And in terms of, we also have very recently guidance on neurodiversity in the family justice system. Which is page 15 of the supplementary bundle.
Yep. Where would you like us to look?
The test, so at page 28, sets out the mechanism for making adjustments to neurodivergence in most family proceedings, and it's a regime in Part 3A and PD 3AA. It goes on to set out terms of the Equality Act 2010 and the overriding objective. Again, at the bottom of the page there, page 29, there's reference there again to the Northamptonshire Council case and the use of exceptionally rare, my lady, and it goes on over the page. See, compelling is used there. We have reference again, this is taken from Crown and Thomas, the application must be considered carefully and with sensitivity, apologies. And then at the bottom there, we have as has already been stated, it will be for the legal parties in the court to adapt themselves to the witness and not the other way around, whilst all parties aided by the opinion of an expert may support the appointment of an intermediary because it will make the hearing potentially easier. That is not the test the court applies, and the judge has to consider whether the appointment is justified. We have that. I don't know, does justified mean necessary? It's possibly it does. Is it semantics? but it's another use of another word. So we have compelling, we have rare, we have justified, and yet the rules are very clear. It's one of necessity. My lady, was there anything particular that your lordships wish me to address you on?
Yes, of course.
Could we look at your position statement at page 62 of the court? Page 62, at paragraph 23. You alluded to this earlier on when you referred to your client's views.
Yes,
You have that paragraph?
I do have that now.
So there have been two guardians,
Yes,
and you're recording what the first one experienced and what the second one felt
yes.
and now feels. Were there position statements? I mean, did the judge have the advantage, as we very often see, for a case management hearing of this sort, that everybody's got their positions in relation to the issues that are coming up for consideration?
My lord, do you mean specifically a position statement, particularly on the issue of
I
intermediary?
was starting on the basis that I presume that the judge has had the benefit of something from somebody before embarking upon the menu of decisions that he had to take. We haven't seen them, and I'm not asking that we should particularly. But
Just turn my back for 1 minute. So my instruction list says there would have been a position statement. She can't remember specifically what was in it, but she does recall that reference to, I think, an intermediary was certainly referenced in respect to the first guardian, but not necessarily in respect to the second guardian.
But what I really wanted to understand was this: that we had a discussion earlier on, you remember, with Mr. Norton about what the judge might have learnt from the intermediary assessor, or the intermediary, who was present in court. Obviously, I don't know, I can't remember what the order says, whether the guardian was present in court on that occasion, but is the information in paragraph 23, this is where I'm trying to get to,
Was that the
information that the judge had,
Yes.
or is
on
it
that
just
day.
information that we now have? Does it say that?
Not likely, because you see what they were attended, they've said. And also over here, also in attendance.
My instructions are that there would have been certainly knowledge of it before because it was set out in a previous document, but not necessarily on that day.
Right. Had there been, for example, any form of guardian analysis by that stage? Or
Check that. Was it now? Right.
Yes.
Can you also check about
yes, why didn't the guardian stand up?
Yes, just-
Right. So, my
Just
lady-
wondering why the Guardian representative didn't just stand up and say,
Yes, it might help, mightn't it?
I'd
Sure
quite like
thing.
to say something.
Thank you, lady. I do have in front of me the position statement that I prepared for the Guardian, who at that time was Josephine Honeyball, on the 22nd of April. And if you look, my lady, if you'd like me to read from that document as to what information was given to the court, I'm happy to do so.
Thank you, that'd be most helpful.
From the Guardian's interaction with Mother, it is clear she struggles to understand and follow conversations appertaining to the local authority's involvement with the child and in relation to these proceedings. The local authority must give reasons why a cognitive assessment has not taken place and further explain the basis upon which it was considered appropriate for mother to provide Section 20 consent to her child being accommodated. Mother requires a cognitive assessment as a matter of urgency, and a capacity certificate should also be completed. An indication is also required as to whether mother will benefit from intermediary assistance.
So the Guardian, it wasn't just the potential intermediary, the Guardian was flagging up potential capacity issues.
My lady, yes.
Well, I just wonder, we needn't spend time on it now, but it may be that information that, if it's agreed between the parties, could be sent to us as, in effect, so that we understand what was available to the judge, not for a hearing back in April. That's useful, but the judge is entitled to have it presented on the day, because I mean, clearly what appears in paragraph 23 would have been likely to be significant in any decision, but it would be useful to know whether the judge had it or whether it was just assumed that the judge had it because somebody had said it
Yes.
before.
I understand. Yes.
Sort of my follow-up was when the judge gave his decision, my understanding is that you said, well, it was rather, everybody was rather taken aback by the fact he hadn't actually heard from anybody else.
I think, my lord, I think they were more taken aback by the decision.
Yeah,
So I
that's
think
what I
the
thought you
idea
said.
was that this application was being made and that they would, certainly on behalf of the child, the same submissions would have been made. But the outcome was what was,
The Guardian was represented at the hearing,
yes.
so but didn't then sort of pop up and say, "Excuse me, would you like to hear from me?"
Mm. Well, yes. I'm told that the judge made it clear he didn't want to hear from anybody else.
No, thank you very much. That's
Thank you
most
very much.
helpful.
Last but not least, my lady and my lords, I firstly thank you for the opportunity to address you all on behalf of the maternal grandmother, and you'll know that I provided a skeleton argument that we rely on. It's always difficult coming in last, and I'll try very hard not to repeat anything that's been addressed and try and assist the court in terms of the matters that have been raised during this hearing. It is a common submission that I make in line with all the other advocates, on the basis that maternal grandmother also says that mother is clearly vulnerable and that the judge was right to make that decision on the 15th of January, and that moreover, in this case, the additional factor is that the other intervener, who's my client's son, was also vulnerable, and that is relevant because it affects my client particularly in relation to the implications of the decision to refuse the mother intermediary assistance. In relation to the vulnerabilities of the other intervener, I've touched upon that in my document. There has, since that document, been a cognitive assessment which sets out in more detail his needs. They include, as we know, a hearing impairment, support of an EHCP, but also additional needs in relation to his emotional maturity, his limited understanding, such that the view is he is not in a position to instruct his own solicitor. And that report concludes that the assistance of an intermediary is advised. On the point as to why his intermediary assessment was funded by the local authority, you've already heard from the local authority in relation to that. I was also at that hearing, and the big issue was the fact that we had the hearing, the substantive hearing in February, and so the worry was, in terms of the timescales, if it was funded by HMCTS, we wouldn't have it in time. In terms of our core submission that I've set out, the decision to refuse the mother and intermediary will impact not only on the mother's ability to effectively participate in these very serious proceedings, but particularly on the maternal grandmother, more so than the other intervener, and more so than the other respondent, the father, who doesn't form a part of this appeal. And I say that particularly because it falls to her to provide the emotional support to her children in this case. And in this case, where she faces the most serious allegations, which will have lifelong consequences for her if they are found, it prejudices her ability to participate in these proceedings. And that came into sharp focus at the hearing after the 15th of January. You've heard that there was a hearing in February, and at that hearing the mother didn't have an intermediary. And there's references already in terms of the role that the maternal grandmother has provided in terms of a support to the mother, both before she became an intervener and post, after the intermediary was refused for the mother. There was a query as to when my client became an intervener, and also as to how many hearings there have been within these proceedings. There have in fact been six hearings to date. Those included, just by way of summary, initially a hearing in April, the 23rd of April, after the application was issued on the 12th of April. A second hearing on the 14th of June. At both hearings, the 23rd of April and the 14th of June, the maternal grandmother attended, and that's recorded in the recital to the order. She wasn't represented at that part, but there was a record in the court order that the court would consider the role of the grandmother at the hearing in June. So that was recorded in the first order. Again, in June, when the maternal grandmother attended, she was an interested party. That was recorded in the recital, and it was also recorded that all parties made submissions about her position, and it was in fact at that hearing that she was intervened formally. She wasn't represented, but she agreed to intervene, and all parties agreed as well. The next hearing was the 14th of August. That's the first hearing before the judge in question. And that was the first hearing at which the grandmother was represented. I've represented her at each and every hearing since. And there was an order for disclosure of all the papers. And thereafter, there was a hearing on the 28th of April, and then the 15th of January.
Sorry, could you say that again?
Yes.
28th of
October, I think you
October.
mean.
I'm so sorry.
You said
October.
April.
I'm sorry. 28th of October, again before the same judge. And then at that hearing in October, it was identified that there would be a pre-trial review on the 15th of January, which could also act as a ground rules hearing. And the fact-finding hearing was listed for 8 days in February.
And at the hearings on the 14th of
28th.
August and the 28th of October, so the August and October hearings, there was an intermediary for the mother.
Yes.
Yes, I mean, I just get the impression, and it's more than the impression, that it wasn't expected on the 15th of January that the issue of an intermediary would be particularly controversial.
That's correct.
That the parties, as it were, had bigger fish to fry
Yes.
with the looming hearing that nobody was ready for because of disclosure issues in particular.
It was a very busy hearing. A lot was happening. There were issues in, I can't recall if it was a case management list or a trial list, but the judge had other hearings. One of the advocates was late. There was an issue as to pre-hearing discussions being hybrid. The police had attended voluntarily. There'd been some communication with the judge in terms of whether the police would be ordered to attend. And those matters were at the fore of discussions at the hearing. And so in terms of the application for intermediary assistance, it was guided by the court. There were full submissions by the mother's advocate, and the judge then proceeded to give judgment. And it was a surprise, both in terms of the decision and the fact that no other submissions were invited. Nobody did say.
Because we've mentioned already the child and the local authority, but in a sense, on the basis of what you've told us, your client had a more than pressing personal interest in this from a number of perspectives.
Exactly. Yes, my lord. And as I said, it came into sharp focus in the hearing after. both in terms of before hearings, after hearings, during hearings. It's common practice to sit with mother, particularly when she's unregulated, leave with mother when mother's unregulated. So it directly affects her ability to participate in proceedings in her own right. And the reliance on her is different from the reliance on the mother's advocate, who has to, of course, field questions from the court. In any substantive hearing, would have to field matters relating to evidence. And so her position is unique in my submission. In relation to other matters that were raised during this hearing, earlier on this morning, I think my Lord had a question about where the intermediary report had been in terms of the availability to the court. It was lodged on the family law portal, which is the electronic court file. So it would have been available to the court if the court had looked, but it's not easy to find, and one would have to search for it under expert reports. It's not unreasonable at all to have expected it to have been in the bundle, the updated bundle, when it wasn't, which is why it was emailed to the judge during the course of the hearing, and that's already been referenced by the appellant. All the other points I'd had have been addressed in some form or other by the other advocates. I don't know whether there's anything else that I can assist with.
No, thank you very much. That's most helpful on behalf of the grandmother.
Thank you.
I'm on my feet just to correct misinformation. I'm told from
Certainly.
behind me that the intermediary contract was available on a publicly accessible website rather than a data request.
Thank you very much. Anything in reply?
My lady, if it assists the court, just three very short matters. I didn't address the court, knowing that others would, on the authorities and the guidance, but may I just address three short matters in relation to more of the President's guidance and intermediaries. Looking at page 3 of the supplementary bundle, at the top of that page is the second half of the
Paragraph.
Jackson, paragraph 4, my lord, has already addressed to a great extent the last sentence, which I think is perhaps the difficulty in that paragraph. What I would say about that is that this being in guidance risks an outcome becoming a principle, and that is the same difficulty with the Northamptonshire case. It is clear that an outcome cannot be a principle that should guide decision making. The second short point in respect of the guidance is in paragraph 7, and this is where there is a difficulty with the rules, because it is very clear in the rules at paragraph 3A.1 the definition of intermediary is as set out in the present guidance. The intermediary means a person with those functions A, B and C, but having that definition doesn't quite marry with paragraph 3A.4 of the guidance, which gives a much broader scope for an intermediary to be involved in the proceedings. And so this may, with respect to President, may not be a fault of the guidance, it may be a fault of the rules, which too narrowly, I say, defines the role of an intermediary. Which then brings me on to my last point in respect to the guidance, which is in paragraph 9, the final sentence. Appointment is necessary to enable a party to participate in proceedings fairly by enhancing their ability to receive and answer questions, perhaps ought to say, including by, rather than limiting it to.
You say that merges together 4 and 5.
It does, yes. The second point, my lady, really addresses the question raised by my Lord Snowden in respect of why we are having this hearing, and perhaps there isn't attendance by HMCTS and by the legal aid agency. I addressed that in part, but the matter came up again. Can I put it in this way? None of us in this appeal is inviting this court to do anything other than approve the already existing rules and the practice direction. It would be different if the rule said intermediaries should only be appointed rarely, and we were inviting my lord and my lady and my lords to change that. We are simply inviting my lady and my lords to reaffirm the test, and my lord and ladies have been addressed by the fact that there is already in place legal aid guidance in terms of funding and HNCTS guidance. So I don't think that's the mission then for them not to be present. My last point, and my lady, is in relation to the draft order. It was drafted over the course of the short adjournment and
Yes.
emailed to
I've just caught up with it. If I think my lord will also have. Just check.
I fear it landed in the inbox as my lady and lords
Walked in the door.
1408. 204. Yeah,
I'm not sure where it's gone to.
well, I can.
I'm a temporary clerk at the moment, so I'm
Well,
just not
I
sure
will-
whether it's made it to my clerk.
Okay, well, it will make it.
Losing through the ether.
And I'll open one that my lady can.
Thank you.
Yes, I see the Constitution is listed in age order. I'm sure that can be corrected.
There are, I've noticed as well, a couple of typographical errors which
Yes.
I.
Well, thank you very much for doing it over lunch.
In terms of the substance of the order, we set out in paragraph 2 the stages in which we invite the court to permit an intermediary, being case management hearings, fact finding, and we include judgment. That is sometimes a difficulty, but is a necessary stage. And then for legal conferences. What we have done is suggest that funding could be different as to between A and B and C, because we had looked at the guidance which suggested that the legal aid agency could be persuaded to fund conferences away from the court building before we had sight, and we're very grateful to my friend Mr. Howard King's Counsel on behalf of the local authority for sending round the contract, which suggests that even those appointments under the contract would be funded by HMCTS. Perhaps time does not permit us to understand precisely the difference between those two guidances. I know
Well, this falls into two camps, doesn't it? In that the court hearings part of it is not obscure. If there is an appointment, then you know who's going to be paying for it.
yes.
Whereas any obscurity there may be concerns C, and if this were the outcome and the court was persuaded to go into C to any degree at all, there's an opportunity for that to be investigated before it actually takes place, isn't that?
Yes.
I mean, it's very difficult for us to make a decision about that, even if we thought it was a good thing to include in the order.
And I think even within those present in the courtroom today, there is a difference amongst the solicitors as to whether that is a permissible disbursement on a public funding certificate.
I'm sure there is.
And of course, they are very mindful of those concerns. Equally, we are mindful on the cost to the HMCTS because it has implications for other functions of HMCTS. I think that's as far as I can take.
Thank you. Well, thank you, Dr. for drafting that over the short adjournment. We're very grateful. I think in that case, unless there's any further submissions or anything else you want to deal with, Mr. Norton will rise for a few minutes.
Thank you.
All those in favour?
don't know if it's
It's still going.
When I
Still going.
the second part.
Sorry?
It's still going.
Oh, okay.
Should we chat?
Still going.
It's still going.
It is still going. Shall we bring it outside, or you're just going to stay to make the videos into it? I think she'll show you.
Still broadcasting.
Hello.
Yeah, he just stopped at nothing. Oh. I've been downstairs. Ah, I see. I am until the resting. I had to start typing down here because I've obviously got long enough arms.
Sorry, I'm Andrew Wilson. If you didn't know your name. You have to say that, don't you?
Yeah, so I think we're probably going to end up walking up to a conversation, point downstairs. Yeah. Sort of straight across the room. Just straight in.
Yes.
That's the plan. Get very close. Yeah. Yeah.
And you come across a name there?
Should put something that is very, very flat.
Oh, dear me.
Absolutely not. No. Yeah, I would.
Yeah, because it's the afternoon, busy.
It's true.
No.
I'm not making up. Yeah.
It's ridiculous.
But I will be. Yes.
I did.
Inside the volume.
We tell them if a name has been said and then someone edits it out and they make it private and then they make it public once it's been cut out. They try to catch as much as they can. But yeah. Because they don't watch it, we have to kind of tell them and they kind of just figure it out.
I needed to be bleeped once because I said a name. But I remember as soon as I said it, I was like, ooh, I didn't do it again. And I'm just getting ready. I've not had any lunch yet. Whilst you were doing your draft order, I was making this good about that and making submissions on the law and all that stuff.
How long the note makes any sense? It's so important, isn't it? So they don't want to really listen to it. I'm not saying anything content. Just the wider campaign, the whole of mine is the judgment.
Interesting case.
Yeah.
Well, I've not been involved in this until now.
Yeah, of course I am. No reason to be. Horrible. I think it's about the crop. No, I haven't. I did do mine this morning before I left. Food for our markets. Exciting.
Court rise of Fable.
Sorry to have kept you all waiting. We took a little longer to discuss matters. So thank you very much again for the draft order. Our order will be as follows. Is that the appellant's appeal against paragraph 2 of the order dated 15th of January 2025, wherein the appointment of an intermediary was refused, is allowed. 2. An intermediary is appointed for the appellant for the following. A. All further case management hearings up until the fact-finding hearing. B. For the duration of the fact-finding hearing, open brackets, including delivery of judgment, close brackets. And C. For legal conferences between the appellant and her legal advisors at court on the above occasions. 3. The cost of the intermediary under paragraph 2 above shall be borne by HMCTS. 4. Any application for intermediary assistance for legal conferences other than under paragraph 2 above shall be made to the judge at the hearing on the 25th of March 2025 or subsequently. No order for costs. So just to clarify, therefore, we are allowing conferences at court. Any applications for conferences other than at court, for example, at solicitors' offices or the like, must be subject to a separate application to be made by the court, to the court, ideally on the 25th of March, but as soon as conveniently be achieved, when no doubt the parties will want to have prepared a much more detailed application explaining what and why such conferences are necessary. Other than that, having indicated that we are allowing the appeal on that basis, we will otherwise reserve our reasons, which we will hand down as soon as we can. You'll get a draft of the judgment in the normal way. For typographical and minor errors only, please not to re-argue the case or to elaborate on people's submissions in any way. The embargo is at the top of the draft, as you're aware, and we expect complete compliance with the embargo. Other than that, I'd hope that any further matters can be dealt with on paper. You effectively have the order already, so I don't think there's any issues such as costs or any ancillary matters to be decided. Yes, and we will, of course, make sure that the order that I've dictated is sent out, so that you have a hard copy, and of course you'll require it for the next hearing. Now, is there anything we've missed out or that we can usefully cover, given that this is still very much a live case? Thank you, Mr. Moore. No?
No, thank you very much.
No. Well, can I thank you all very much indeed for your considerable assistance and your for all your written submissions. I see that we've got Ms. Reeves sitting in the back of the court, I think, for some of the time, and we found the intervener submissions extremely useful, and no doubt they'll be referred to in our judgments. So the fact that we haven't had the interveners represented in front of us today doesn't mean to say that we haven't found them extremely valuable. Thank you all very much indeed.